or before the court is whether I should allow Mr. Masengeli, the contemner who is before the court, to explain why he deliberately disobeyed the orders of summons by the court, which led to his conviction and sentence. The Law Society of Kenya, led by the President Emeritus Nelson Havi, has urged me to deny Mr. Masengeli the opportunity. He has revealed to this court from the bar that the missing persons have now been released, and all I should do is to allow Mr. Masengeli to confirm that he has complied with the orders of the habeas corpus so that these proceedings can come to an end. Additionally, he has argued that Mr. Masengeli has filed 2 applications before the Court of Appeal where he has appealed against a conviction and sentence, and one where he seeks an order of stay of these proceedings. Mr. Dan Manzo has argued or submitted that the court is now functus officio, since the jurisdiction of this court now rests with the Court of Appeal, has now been vested with the Court of Appeal following the filing of the 2 appeals. This position has been strongly opposed by counsels for the first respondent, Mr. Miller and Mr. Ogola, who have argued that the court gave a coercive order which end compliance requirements. Further, the proceedings before the Court of Appeal are intended to deal with the conviction aspect and not the sentence. In making a decision on the issue before me, I must make a reference to the sentence of the order I made on the 13th of September 2024. In sentencing for contempt, there are normally 2 ways of punishing a contemner. Okay, 2 major ways. The court can choose to adopt a purely punitive approach, or can choose to use a coercive approach in which it includes what is known as the purging conditions. The coercive approach gives the contemner the opportunity to save himself from punishment, the equivalent of purgatory in religious circles, so that if the contemner complies and fulfills the obligation required of him by the court can weigh and consider whether he has cleansed himself of the original sin. In my ruling on the 13th of September 2024, I had this in mind when I included condition number 4, which stated as follows: the court nevertheless considers it desirable to impose a coercive order as opposed to the punitive order. In this regard, Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend the sentence for 7 days only. The acting Inspector General can redeem himself by availing himself before the court in person to answer to the issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. Having stated as much, and the contemner having availed himself before the court before the lapse of the 7 days, I would be going against my own orders if I deny him audience as urged by the LSK. This is a court of justice and must act fairly at all times towards those that appear before it. Mr. Masengeli is entitled to be heard by virtue of this court order. The Court of Appeal has not taken away the jurisdiction of this court, for it has not issued any order barring this court from hearing Mr. Masengeli. This court is not functus official either, as the sentence was not purely punitive but coercive, laced with purge conditions that the court reserved to consider before the sentence becomes effective. I will thus allow Mr. Masengeli to take to the stand and redeem himself.
Most